Today we had the prosecution extension request, the request to extend the measure of preventative arrest, a procedure which the defense considers obviously unjustified and totally exaggerated, especially in the conditions where we still maintain that the evidentiary support is completely lacking in this case, and what has been disseminated in the press is nothing more than a completely and utterly exaggerated and distorted interpretation of harmless private conversations of the persons concerned, who have been given a completely and totally unjustified, exaggerated interpretation. We must somehow point out that after going through all the documents and all the materials supporting the criminal investigation, our position is firm that there is no evidentiary ensemble of the nature needed to indict the clients we represent, and even more so, to justify maintaining the arrest as legal or as well-founded. We continue to maintain that, basically, at this point in time, they're arrested for an offense of opinion, for what they said at some point in the online environment, and not for what they actually did in their private lives.
Did the prosecutors have to present new evidence for the extension?
They didn't present new evidences for the extensions. They talked about the fact they have to re-administrate some evidences, or the fact that for the investigation in that moment, at this moment, is better like the defendants to stay in arrest.
What do you mean by better? How did they argue the case?
It is by our procedural penal code. It is one of the facts, one of the reasons one defendant should stay in the arrest for good development of investigation.
În legătură cu măsura
The news, what new? Because we don't have any news. The court didn't give us a solution today. We wait the solution of the judge. And we are optimistic this time.
Why?
My colleague, the other lawyer, just said why.
What has happened in the seizure of assets? Two more requests to waive the injunction of precautionary seizure of assets are to be adjudicated. I would also like to point out that now, despite the fact that since the 5th of January, we have made a request for evidence for the two defendants, which included, please pardon my language, the questioning of these defendants and the questioning of other people who may present new elements that are, we say, eloquent for their innocence. Further, no act of prosecution from the request for probation made by the two defendants was administered, which already seems to me to be inadmissible. We are already on the 22nd day after the measure of preventative arrest was carried out. What is the state of their general health? As we know that last time Andrew suffered several problems and had to be transported to the hospital. I'd like to clear this up once and for all for the media, because I've seen a lot of articles about us lawyers using it in our defense. Their state of health, we would justify ourselves, we would motivate ourselves why they should not be in prison. This is utter nonsense, as it is not happening. Andrew is in a poor health due to the pre-existing condition, and I'll stop here. My client doesn't want to talk about it, nor does he want to use it in his defense, nor was such a theory supported in the pleadings of the lawyers. I would like to make it clear once and for all. The fact that his health has worsened, or the fact that he had to go to the hospital, it is true, but it's not the basis of the defense, and he is not using this argument to justify a possible request for a release. We see that the trial of this measure happened quite quickly, as in theory the 30 days have not yet expired. This happens correctly because it should be judged at least 5 days before the expiry of the arrest warrant, as against this solution today an appeal can be made, so that the judges can have time to motivate their solutions, to send the file to the superior court in case of a possible appeal. Of course, this is always judged a few days before. Now that I understand, Tuesday is a day off, and maybe even Monday. As the arrest warrants were due to expire, all the more the deadlines had to be respected. Do the Tate brothers want to send the message that they are absolutely innocent, and they hope that the justice system in Romania will prove this? What do you think about the international media that roars about everything that happened here in the country and about the alleged established businesses the two of them have. They didn't express their opinion. You must understand that our relationship as defense attorneys with our clients is limited to discussions related to the case, to discussions related to the defense. No, it really isn't the time nor the environment to discuss opinions about the international press. It's kind of a professional relationship and we wanted to stay in that area.
Just one quick question. Did Aiden Ross request to visit Andrew Tate in prison, was it allowed or was it confirmed?
I received this information yesterday. I visited yesterday in the evening Andrew, but I didn't ask him. And from my point of view, he didn't have the possibility to visit Andrew because he is not a relative. So the prosecutor, I think, that didn't admitting the request.
And just one last question, please. We published today on the BBC a article alleging that Andrew and Tristan Tate were contacting teenagers. Did they respond in any way to that article, or do you have a comment?
Is that a crime?
Well, it's not a crime, but it is a behavior that suggests they were contacting teenagers in a certain pattern to possibly recruit them for their activities.
Officially, I don't have this information, and they didn't comment any of these arguments.
Will there be further arrests? We don't know.
Ancheta este acum sus, ședință publică pentru contestație la